Good afternoon, everyone. Thank you for attending. We're seeing the attendees still coming in. So for those of you all who are here, good afternoon and welcome. Welcome to the Law Association of Trinidad and Tobago in association with LexisNexis Legal UK, our joint webinar on ethical intelligence, using artificial intelligence responsibly in legal practice. So, as you all would have seen from our agenda, we have a lineup of very established speakers for you. So as attendees continue to make their way in, I'm going to give you a brief bio of each of our distinguished speakers this afternoon. First, we have Mr. Scott Wiles. He is the Director of Caribbean Markets of LexisNexis Legal UK. As Director of Caribbean Markets at LexisNexis UK, Scott leads strategic growth, market development, and client engagement across the Caribbean region, ensuring exceptional value for legal professionals. He is also a recognized educator and advocate for the ethical use of AI in legal practice, regularly providing training and thought leadership across the Caribbean legal sector to help professionals apply AI responsibly while upholding legal integrity. With over 15 years of experience, Scott is committed to delivering tailored solutions that address the unique needs of the Caribbean legal community. Scott, we welcome you and we look forward to hearing you on understanding the machine, how AI is changing legal practice. Next, we have Mr. Ian McDougall. He is the president of the LexisNexis Rule of Law Foundation, a charitable organization registered in the US and established to advance the rule of law. Ian is the chair of the United Nations Global Compact Legal Advisory Board and a professor at IE University in Madrid, teaching the rule of law and artificial intelligence and the legal profession. Since 2023, he has been a trustee of the Civil Liberties Trust in the UK, and since 2024, trustee of the International Bar Association Foundation. Until September 2024, Ian McDougall was the Executive Vice President and General Counsel for LexisNexis, having been with LexisNexis for 20 years and having been involved with artificial intelligence issues for the last 10 years. At LexisNexis, Mr. McDougall stepped into various roles, including CEO of the Asia Pac, HR Director and Managing Director for LexisNexis New Zealand. Mr. McDougall, we welcome you and we look forward to hearing you on balancing innovation with integrity, ethical and legal considerations. Our third speaker this afternoon is Mr. Jason Nathu. He is an attorney at law admitted to practice in Trinidad and Tobago in 2006 and in Guyana in 2023, with over 18 years of experience in civil litigation, intellectual property, family law, conveyancing, and estate matters. He currently serves as a full-time faculty member at the Hugh Law School in the Legal Aid Clinic. He also supervises the Human Rights Law Clinic and the Innovation, Technology, and Entrepreneurship Clinic, and is an associate tutor in the Law Office Management and Technology course. At the Legal Aid Clinic, Jason maintains an active litigation practice. He regularly appears before various courts and tribunals of Trinidad and Tobago, including the Court of Appeal, the High Court, and the Equal Opportunity Tribunal. He has acted in significant matters in copyright law and anti-discrimination law in Trinidad and Tobago. Jason is a former member of the Council of the Law Association of Trinidad and Tobago and continues to serve on its Information Technology, Human Rights and Publication committees. He holds a Bachelor of Arts in History and a Bachelor of Laws from the University of the West Indies, a Legal Education Certificate from the Council of Legal Education, and a Master's in Law in Intellectual Property from the University of London. Jason frequently speaks at regional and international conferences and has published widely on topics including intellectual property, artificial intelligence, and clinical legal education. He is particularly interested in the evolving role of technology in legal practice and its potential to transform justice delivery in small jurisdictions. Jason, we welcome you and we look forward to your presentation, Responsible Adoption, Best Practices for Legal Professionals. So, without further ado, gentlemen, Scott, the floor is yours.
Thank you very much, Jonathan. I'm going to do the obligatory. Can you hear me, Ian? I can see you. If I could get a nod of the head. Excellent. Thank you, Ian. Well, good afternoon, everyone. I'm now going to endeavour to share my screen as well as I introduce myself. So hopefully this works. It is my job to can I just confirm, Ian, can you now see my slides understanding the excellent? There we go. Thank you for that. So and a thumbs up as well. So I think it's fair to say I am the warm-up act for this afternoon, everyone. Just hearing the long list of accreditations that my two co-speakers have, but it is my job to introduce you to the session and the topic today under the title for my segment, which is understanding the machine, how AI is changing legal practice. So I've been working with firms in the Caribbean specifically for the last 4 years on this, and I've witnessed a huge transition in that time. Now, of course, I'm talking about AI in the last couple of years, but also in regard to the region's adoption of technology and legal technology more generally. Our Caribbean clients have actually been the segment most eager to implement AI in their process. And of course, with that comes the need to educate and to understand the risks and how to operate with best practice. So I'm going to take you through this overview and then hand over to those headline acts. So I'll start with a story, which will probably resonate with many of you. A story of a junior attorney late at night, under pressure with too many files and not enough time. So she turns to ChatGPT there. Ironically, I use ChatGPT to generate that image, but it drafts her a submission, includes 2 case citations. She submits, only those cases never existed. Now, this is not a tech dystopia headline or a courtroom drama. It's happening. It's happening in the UK. And of course, it's happening in the Caribbean as well. And there are real consequences to this. And this isn't an issue of bad intent, but generally one of misunderstanding. Now, AI is already in legal practice. The genie is already out of the bottle, so to speak. We actually surveyed over 1,200 lawyers recently, and 80% are either already using or planning to use generative AI in their profession. Now, with that, many actually are feeling left behind or concerned over their understanding of the technology. Now, today isn't about fear, far from it. It's about clarity. It's about what the technology is really doing, understanding that, and how you make it work for you, both ethically, intelligently, and in the context of Trinidad and Tobago and the wider Caribbean too. Now, I'll take this opportunity first as I introduce what generative AI is, and I promise this won't be a series of how to suck eggs, is a statement taken directly from ChatGPT itself, which probably makes you pause for thought somewhat, which says, a note about accuracy: services like ChatGPT generate responses by reading a user's request and, in response, predicting the words most likely to appear next. In some cases, the words most likely to appear next may not be the most factually accurate. For this reason, you should not rely on the factual accuracy of output from our models. So they say it themselves. And this is, again, this applies to general AI tools more widely than just this particular brand, I should say. Now, let's demystify that. Generative AI doesn't know the law. It isn't reasoning. It's trained on massive amounts of text, and it's just predicting. It guesses what word comes next in a sequence to sound convincing. And that's why when ChatGPT or another AI service says, according to Smith versus Roberts 2016, even though no such case exists. Now, these errors are called hallucinations, and they're especially dangerous in law because they sound really convincing. They sound right. Think of these tools more like a parrot with a photographic memory and very good diction. It can sound brilliant, but also be utterly wrong. Now, contrast this with a built for legal AI tool like Lexis AI, for instance. Now, these tools don't generate language. They ground every output in real citable sources from a legal context. You can trace every quote, every reference, and there's a massive difference there. And it only works if you know what you're using. Now, I'm going to endeavor to show you a video with some sound now, which hopefully you'll all be able to hear, which will help illustrate the point somewhat.
Nathu v. Stevenson clearly states you must never pour ginger beer into the ear of an enemy. Don't worry, I'm not real. But your AI better know the law. Nathu v. Stevenson.
So to prove a point there, I think not everything you see at first view can be taken at value and must be looked into. So hallucinations remain the biggest concern amongst attorneys, and for very good reasons, as we just touched upon. But what I'd like to do is have a look further at how AI built for legal works and how that's different, and some of the use case and efficiencies that you can actually stand to gain by the effective use of that. So what does good use of AI look like in practice? I'm going to take these three use cases, these three areas that you'll probably recognize: legal research assistance, drafting and document automation, and litigation analysis. Now, legal research assistance, legal specific AI assistants like those integrated into Lexis AI can summarize a case, they can extract key points and answer natural language questions like, what is the procedure for obtaining a final injunction, for example? Now, what you'll get here with a built for legal AI is a grounded response, plus links to the actual cited cases, practice notes, legal commentary, whatever it's used to generate this response. You'll see here illustrated by the hyperlinks within the text. You click on that and it will take you through immediately to the content it's used to generate and is sourcing for this. And it's a little bit like having access to a learned colleague 24/7. Drafting and document automation. So in Word, tools like Lexis Create can actually suggest clauses, detect inconsistencies, and draw from a precedent bank whilst you type. So you can also upload and modify documents, which the video should show in a moment, safe in the knowledge that it's not being used to train the model or at risk of breaching confidentiality. For example, you can see here the user has uploaded a document and actually asked it to make that particular contract more favorable to the seller, for example. Now, what's really important here is nothing that gets uploaded into Lexis AI, for example, is used to either train the model or used in any other way. It's fully encrypted. No one at Lexis even sees what is being uploaded there. I recently saw a firm in Barbados use this to half the time they spent on supplier contracts. So for them, it wasn't so much about revolution, it was about reliability. And then finally, litigation analytics. So in markets like the US and soon to be across the Commonwealth as well, tools like Lex Machina analyze judge behavior and case outcomes. So fantastic from a litigation perspective. And one US firm that I saw an example of recently used it to estimate settlement windows on commercial disputes. So actually not just smart, but strategic. I think what's really important to point out here is that what I'm showing you now, these aren't tomorrow's tools. These aren't those conceptual ideas of what may be impacting the legal industry in the years to come. They're already working. They're in small firms, large chambers, in-house legal teams across the Caribbean and the UK. So all of this is leading to a bigger shift. Today's attorneys are squeezed from every angle. AI isn't just changing the way in which we work, it's changing what's expected of you as practitioners. You're squeezed between client expectations and other market forces, but also those growing business demands as well to keep generating fees and to importantly demonstrate ROI. So it's a it's a tough gig. It's a tough situation that you find yourself in. And what's changing in legal practice? Well, faster turnaround. Clients know that you've got access to tools that reduce legal research from hours to minutes. They expect that speed. In fact, they're testing out themselves by using free resources to get an idea of what your argument might be or your position might be. And if you don't offer that speed, then someone else will. There's a junior lawyer evolution. So the days of spending 2 years summarizing judgments are fading. AI does that now, and juniors are being asked to interpret and advise much sooner than they would have done previously, which means how you train them needs to evolve as well as a result of this. From a competitive edge perspective, firms using AI aren't just faster, they're actually more consistent. They're providing better client outcomes in many situations, and they can offer fixed fees with confidence, and that's a competitive edge in any market. But there are real risks inherent with this use, and this is critical. Using unverified AI and trusting outputs blindly, it's not just unprofessional, it could be unethical. Now, specifically for Caribbean attorneys, what is the importance of AI? Well, it's enhancing legal efficiency. So it's helping to streamline legal research and case analysis, and it's reducing time spent on routine tasks, allowing attorneys like you to focus on complex legal issues and really instill their value in the process much more quickly. But across the Caribbean, it's also improving access to justice. AI-driven solutions are expediting court processes. They're making legal services more accessible to the public and ensuring timely justice delivery. And they're also making firms more competitive. So we've seen through this adoption of technology generally and AI that it's helping to level the playing field between the smaller firms that are, some 90% probably of the Caribbean market, and giving customers more choice. And it's driving economic growth as well. So AI adoption in the legal sector actually contributes to broader economic development by increasing productivity and creating new opportunities within all aspects of the economy. So we've arrived at the heart of it. As lawyers, your value is built on trust. You don't just say things, you prove them. You cite, you verify, and you stand behind your work. Well, AI doesn't change that. If anything, it heightens it. You wouldn't walk into court with an argument based on a rumor. So why would you do it based on a chatbot? Now, understanding AI, its power and its limits is now part of a professional duty. It's not optional. It's not a tech issue. It's a standards issue. And if you approach it wisely, you don't just protect your reputation, but you actually elevate your practice as well. And of course, there's been many references of it within the broader region as well, with the CCJ guidance being one of the very first to offer such a guidance, and it reiterates the need for absolute clarity and responsibility for what is submitted. So very quickly, some of the common pitfalls that we are seeing with AI in legal practice, and something to be aware of, is an over-reliance. So an over-reliance in AI without human oversight. So if anyone's ever seen AI spit out something that looked perfect and supported their point to the T, I would read that again quite carefully and make sure that's actually what it's saying or that it actually exists. We've got privacy issues. So people are rightly asking, where does our data actually go and who sees it? A clear distinction again on that, one of those first slides, between a legal or a built for legal AI versus a more generalist AI. And there's also misinterpretation of AI generated insights. So AI sounds very confident even when it's wrong, and that can trip up newer staff and experienced staff too, but also clients. So I'm sure There's probably you probably recognise some of these in your working practice or in some of the reports you may have read. And remember, if it doesn't fit into your workflow, then it's probably ironically slowing you down. I started with a story, so I'll add another one for illustration now as well as I get towards the end of this. But I was speaking to a Bayesian attorney maybe 3 weeks ago, and this particular attorney was very proud of the fact that he used a generalist AI tool. Well, he used AI generally all the time. He was using it in his professional life and his personal life, and in his mind, generating a lot of efficiency from it. And he actually asked me the question, why, if I can get this for free or for a very low fee, why would I pay for a built for legal AI solution from yourself? Which for me that's fuel for the fire. I love these conversations. And I asked him, actually, in fact, he said to me, look, I know what you'll say, hallucinations. You can't use a generalist AI tool for this reason. So I'm aware of these. So every time I use a generalist AI tool for my research, I will do my due diligence afterwards. I will make sure that I look into each of those cases to make sure they say exactly what I think they say and that they exist. I said, good. That is the pitfall that many people fall for. How long is it taking you to carry out that due diligence? And without blinking, he said, well, probably 3 to 4 hours each time. And what he failed to realize at the time it saved him up front in finding those particular cases, he was then subsequently losing when he was doing his due diligence. Now, with Lexis Plus AI and presumably other built for legal AIs as well, that citation and that due diligence is made very quick, very easy for you because it surfaces everything that it's used to cite and to generate that response. And you know that it's come from a trusted resource. I then asked him if he found redacting information and whatnot before uploading content into these AI tools. Found that it negated the time it took to do that, negated the benefit that he got, and actually the response was that he hadn't even considered the privacy and security issues there. So again, something to be aware of. So very briefly then, how can Caribbean attorneys prepare for and adopt for these changes? Well, you've got to think about how you're prompting, right? And I know it gets referred to as prompt engineering, which probably makes it sound a little bit more technical than it is, but you've really got to think about what you're asking in context to get the right responses. So prime it, include context within your prompt. What are you looking to do? What do you know about this particular situation? Persona, so share a desired personality, background, and tone to shape the output, either your own or that of your client, for example, to help give it more context. Give it really clear and specific instructions, as if you were a junior in the office, for example, or if you were instructing a junior in the office, I should say. Be really clear on what you expect to see. And specify what output you want back from the system as well. And then elaborate, refine, and verify through the conversation with the system, because that's what it is. It's a back and forth to get you to that response much more quickly. And again, this is not about replacing the work that you do. It's about getting you from a blank page, for example, to a first draft or 40% of the way there much more quickly, and enabling you to employ your value in the process much more quickly. So to close this segment, I'll leave you with a thought, and that's that AI doesn't replace lawyers, it replaces tasks, and it amplifies the skill of those who use it well. Now, I'm going to endeavour to hand over to Ian McDougall, who's going to explore the ethical and legal guardrails we need to follow as this technology becomes more deeply woven in the legal profession. Because if we're going to use AI, then we need to know how to do so with integrity. So Ian, I will stop sharing and I will hand over to you.
Okay, thank you very much. Yep, and first of all, thanks for the opportunity. My only regret is that I can't actually be delivering this talk in person in Trinidad or Tobago, which I would love to do. The other thing I would say before I start is that some of what I say will overlap with what you've just heard, but I think it's important to do so because it's relevant to the topic that I'm talking about, the considerations about using AI. Now, I don't need to hype the advent of AI. But even so, I don't think it is actually possible to overhype it because of its importance. Sorry, we stand at a crossroads in the legal profession, the fourth industrial revolution it's been called. But the difference between this one and past industrial revolutions is that the previous ones mainly affected physical processes. The fourth industrial revolution, for the first time, affects what I call the cognitive industries: law, medicine, science. And this is what's scary for the legal profession at the moment. It's been moderately affected by technology, but this technology will completely revolutionize the industry. In fact, all of the cognitive industries, as I call them. And that's scary because behind us lies centuries of tradition, precedent, time-tested practices that have formed the backbone of our legal systems. And ahead of us stretches a digital frontier where artificial intelligence fundamentally changes how we do everything we previously associated with the skill set of being a lawyer: research, analysis, drafting. And eventually, even the application of reason through legal problems will be having AI input. The question now is not whether AI will transform legal practice. The question is whether we can harness its power while preserving the integrity, ethics, and fundamental values that define the legal profession. Now, despite all the stories that you hear about AI getting things wrong, you've just heard about hallucinations, for example, and it does, and I'll return to that a little bit later. The now rapidly realizable, not potential, realizable benefits of AI in law are undeniable. AI-powered research tools sift through millions of documents in seconds, identifying relevant cases and statutes that might take a human lawyer days to find. Contract analysis can spot inconsistencies and risks across hundreds of pages of complex agreements. Predictive analytics help attorneys assess litigation outcomes and settlement values. But for solo practitioners and small firms, I genuinely believe that AI actually levels the playing field, providing access to capabilities that once could have been the reserve of large corporate law firms. Because don't forget, if you take, for example, the Lexis service that the sole practitioner subscribes to is identical to the one that a large law firm subscribes to. They're getting exactly the same artificial intelligence service. That is very leveling of the playing field. And of course, it doesn't forget. It remembers everything it's ever been told. You can't. And so competing against superior skill sets, a losing proposition. But these tools don't just deliver efficiencies, they can deliver better outcomes for clients if we go about this the right way. When AI helps us identify relevant precedent, catch every potential issue, analyze every angle of a case, lawyers will serve their clients more comprehensively than ever before. In a profession where missing a crucial detail can mean the difference between justice and injustice, AI's thoroughness is not just convenient, it's potentially life-changing. But with this great power comes great responsibility, as has been said by Spider-Man's uncle, I believe. Our profession is built on respect for the skills and what we do, and on trust. Trust from clients who share their most sensitive information, trust from the courts that rely on our candor, and trust from society that depends upon our commitment to justice and the rule of law. So AI will require us to maintain this trust and respect, but in new ways. And that's the scary bit. Lawyers are unsettled by new in their search for certainty. But if the legal profession is to retain its important place in society, as it must if the rule of law is to continue and be strengthened, then it must deliver the benefits while maintaining the trust and respect. I'm going to briefly go over again what was just said about the workings of what I call open large language models, like ChatGPT and others. Now, as you know, stage 1 of training means that it goes out into the internet and it vacuums up every word it can find, and it generates an algorithm that creates links between words. It then uses those links to predict the next most likely word in a sequence. That's a number of important things. It does not understand the words in the cognitive sense. It understands links between them. It does not understand right from wrong, truth from fiction, bias from fairness. It's doing what Alan Turing called playing the imitation game. It's pretending that it does. It's fooling you into thinking that it knows what it's talking about. It doesn't have a moral understanding. So I liken it to an atom. The atom doesn't know whether it's in a bomb or an electricity generator. It just does what an atom does. So the moral, ethical viewpoint must come from us. The OpenAI model has absorbed all of the bias, prejudice, error, misinformation available on the internet and treated it all the same. Now, of course, then you get what's further refined training, which is fine-tuning in the jargon of the business. System like the LexisNexis system is trained, further refined, so that its answers are limited down to the contents of a curated database, thus eliminating all extraneous materials from its answer set. I've never tried this, by the way, but I would imagine that if I asked the Lexis database who won the Soccer World Cup in 1970, it would not know. Whereas, of course, ChatGPT would know that it was Brazil, because that's the most likely connection between World Cup 1970 and winner. But that's an important point, isn't it? Because when you go to a lawyer because they've been specifically trained in AI. You don't go to a lawyer because he knows about soccer. So it's an important connection between the human skill set and the AI fine-tuning skill set. Unfortunately, as you've heard, many lawyers are still relying upon open AI models, and so my comments now are sort of directed really at that use. Now, most rules of professional conduct require, or certainly should require, lawyers to provide competent representation. Competency means more than simply being able to regurgitate large tracts of law from memory, as showy as such a skill can be. I suggest it's a skill that will be increasingly for a bygone age. But to balance that point in an AI-enabled or AI-driven world, this means we must not simply delegate critical thinking to the algorithms that the user doesn't understand. We must comprehend the capabilities and limitations of the AI tools that we use. And I believe this now should be part of every lawyer's training and education. Where an open AI model generates a legal document, for at least the foreseeable future, knowing what I've said about open AI models, the user has to verify its responses. And as I say, unless using a trusted legal database like the Lexis system, which kind of hands you the verification on a plate. But when it analyzes a contract, we have to understand what it's doing. When it predicts case outcomes, we have to recognize the assumptions underlying those predictions. This isn't merely a technical requirement, it is a moral, ethical one. Our clients deserve and require lawyers who understand the tools they use. Courts and the administration of justice require advocates who can explain and defend their arguments, not merely recite what an AI tool has produced. Now, as you heard, Scott touched on this, but client confidentiality has always been sacred to the profession. But AI represents new challenges to this duty. When someone inputs client data into an open AI system, are they sure where that information is going? How it's stored? Who has access to it? Is it being used to train the model that might later be accessed by opposing counsel or competitors? In fact, use by models that may openly repeat that information. And if anyone can remember, much to their detriment, the folks at Sony who put a load of their patent information into the open AI and suddenly found that it was being repeated and reproduced all over the place, which I think blew their patents or their attempts to get them. Now, these are not hypothetical concerns. As I've said, we've seen cases where lawyers inadvertently disclose privileged information through AI tools. We have to implement robust reviews to protect client data. Vet the AI vendors. Get the assurances from them and ensure that pursuit of efficiency doesn't compromise client privacy. Now, behind every case is usually a human story. Behind every legal principle is a human value. Behind every decision is a human consequence. Now, AI can process information and identify patterns, but it cannot, for the foreseeable future at least, understand the human context that gives meaning to the law. Consider the lawyer advocating for a client facing deportation. AI can efficiently analyze immigration statutes and identify relevant precedents, but it can't understand the fear in the parent's eyes. It can't make the moral argument that transcends legal technicalities, and that may even result in overturning a previous precedent that AI would presume must be followed at all times. Some of the great transformative cases in history would never have happened if we had just blindly followed an AI answer that consisted of "you will lose." It's interesting that that little video showed the someone referencing Donoghue and Stevenson. At the time that Donoghue and Stevenson case was started, it was hopeless. All precedent was against it. It took repeated appeals up to the highest court for them to decide that the law was actually something different than the whole history of precedents had been up to that point. So again, there is an opportunity for human beings to play a role in the outputs that AI generates. It cannot provide the human connection that makes the difference between how a judge might view a case, or at least perhaps until we get robo-judges. But so how then do we navigate this landscape responsibly? I propose a few principles. Every OpenAI generated output must be verified by human expertise. This means checking citations, validating legal reasoning, and ensuring that AI recommendations align with ethical standards. We have to treat AI as a powerful research assistant, but not as a replacement for ethical judgment. AI can, as I call it, end the tyranny of the blank page, but you should not think about unquestionably following it. I frequently say in the talks that I give, don't become a tech zombie, a passive and unquestioning recipient of everything it throws at you. I say the same about social media, for that matter. And the next point is that as AI technology evolves rapidly, so must our understanding of it. We must commit to ongoing education about AI capabilities, limitations, best practices. This is not a one and done thing. Bar associations, law schools, continuing education providers have to step up to ensure lawyers have the knowledge they need to use AI responsibly. And well, and you heard, for example, the prompt engineering discussion. It's really interesting. I went through a prompt engineering little session course from an expert. And what it does is it transfers your input from being a single sentence, tell me about this, to being a whole collection of instructions and advice and different things. Tell me about this, but do it in this way, from this perspective, so that I get this kind of outcome. And eventually you have quite a long list of instructions for the AI, which tailor it to specifically what you want to do. But that requires training. And so I ask for your support in my campaign to get these things, along with the rule of law, taught in every school and every college around the world. The next principle is data protection. We have to obviously implement comprehensive data protection protocols when using AI tools. This includes careful vendor selection. And you've just heard, for example, the fact that that Lexis protects the information that you input into the system. That's very important, and that's very good. Thorough contract review, data encryption, access controls, regular security audit. And so does your firm, for example, have a policy or written instructions as to how your staff should engage with AI? That's an important thing. And you know what? It might sound a bit trite, but sometimes having that policy can help you defend against some actions, because it shows that you've taken some kind of reasonable action to try to secure client data. Our clients' confidential information should be protected with the same vigilance in the digital realm as in the physical world. And this is where I believe that some law firms who are trying to develop their own AI systems will run into trouble. I think that's completely mad. It's doomed to fail, in my view. They have neither the resource, the expertise to wage the constant security war that's required in the modern online world to protect data. That's the important thing. Not that can they do it? Can they produce a large language model themselves? Yes, they can. But can they spend the hundreds of millions of dollars every year in security alone that has a chance of preserving the integrity of that data? I suggest not. The other point I would make is implications for justice. Our individual choices about AI use have broader implications for the justice system as a whole. Obviously, if only well-resourced lawyers and law firms have access to the most advanced tools, we risk creating a two-tier system of justice where the quality of legal representation depends on technology rather than legal skill and dedication and justice. Conversely, if AI democratizes access to legal analysis, it helps level the playing field and improves access to justice. Solo practitioners, I believe, can compete very effectively with large firms when they're subscribing to effectively the same tool. Legal aid organizations can serve their clients with limited resources. The key is ensuring that AI enhances rather than replaces human elements that make legal representation meaningful. So looking forward, as we stand at the crossroads, we have a choice. We can fear AI and resist its adoption, and you would be surprised at how many people try to do that in some way or another. And that potentially leaves our clients underserved and the profession behind. Or we can embrace it. Now, we can embrace it in a thoughtful, ethical integration of AI that enhances our capabilities while preserving values. I believe in what I call surfing the wave of change and staying ahead of it rather than being washed away by it. The new cliche is that there'll be two types of lawyer, those who embrace the change and those who fail. But staying ahead of the change curve also means one important thing. You have greater control over your destiny rather than being pushed around by it. This is the same in the world of regulation. Lead the change, regulate appropriately before a politician comes along and does it for us. And this requires action from all of us. Individual lawyers must educate themselves about AI and implement ethical guidelines for its use. Law firms must develop AI policies and training programs. Bar associations must provide guidance and update ethical rules to address AI-specific challenges. Law schools must prepare the next generation of lawyers for an AI-enabled profession. So I'll come to my conclusion now, which is that the future of legal practice will be shaped by how we respond to AI. We have the opportunity to harness this powerful technology to serve clients better, make the profession more efficient, and expand access to justice. But we have to do so without compromising the integrity, ethics, human values, the way that we do the job, our conduct that defines who we are as lawyers. This is not something that's outside of our behavior. This is something that we incorporate into ethical behavior. Innovation without integrity is just technological change. Integrity without innovation is stagnation and irrelevance. But innovation with integrity, that's the path to a legal profession that honors its past while embracing its future, that serves clients more effectively while preserving the trust society places on us. The choice is ours. Let's choose wisely, act ethically, and ensure that we transform our profession. But while we transform that profession, we remain true to its highest ideals. The future of law depends not on the sophistication of our algorithms, but on the wisdom of our choices and the strength of our commitment to justice. Thank you.
So I want to thank Scott firstly for his presentation and then Ian for following up. Definitely a lot of food for thought there, and we're going to get into that in the Q&A section. However, at this time, I'm going to invite Mr. Jason Nathu to give us his presentation on best practices for legal professionals.
Thank you very much, Jonathan. We've heard a lot from Scott and Ian today about how fast AI is moving and how much potential it holds. But with that momentum comes a responsibility to make sure that we, attorneys at law, are adopting these tools with discernment, integrity, and a clear understanding of the risks. And before I continue, let me just ask Jonathan or Scott whether you all can see my slides. Yes, Ian is saying yes.
Yes, we can.
So in this final segment, I would like to pivot from what's possible to what is responsible and walk you through 10 best practices that can help guide ethical and confident AI use in legal practice. We are at a pivotal moment in the legal profession. AI is no longer an abstract concept. It is embedded in how we research, how we draft, how we communicate, and how we manage our practices. This brings tremendous opportunity, but also real risk. As of today, the 2nd of July, 2025, there are 164 cases identified so far around the world where generative AI has produced hallucinated content. 4 in Australia, 5 in Brazil, 7 in Canada, 1 in India, 1 in Ireland, 18 in Israel, 1 in Italy, 2 in the Netherlands, 2 in New Zealand, 3 in South Africa, 1 in Spain, 1 in Trinidad and Tobago, which many of us are familiar with by now. That is the case of Next Gen Pathology Services Limited versus Duncan. 9 in the UK, and 106 in the United States. Hallucinations are happening and courts are responding. With that in mind, here are my 10 practical tips to use AI ethically and wisely in our legal practice today. Some of what I'm going to say you've already heard from both Ian and Scott. Some might sound like common sense, but there are 164 and counting cases. So perhaps it's worthwhile to listen to some of this again. So tip number 1, always verify your sources. This is the foundation. AI tools like ChatGPT, Copilot, and Gemini can generate case names, summaries, and statutory language that sound right, but that does not make them real. Cross-reference every case, every statute, every quotation against reliable court judgments, official law reports, and reputable legal publishers like LexisNexis. This quote is directly from the May 2025 King's Bench Division case of Ayunde versus London Borough of Haringey in the UK. The quote is, "Those who use artificial intelligence to conduct legal research, notwithstanding these risks, have a professional duty, therefore, to check the accuracy of such research by reference to authoritative sources before using it in the course of their professional work to advise clients or before a court, for example." The moral of the story is, if you can't find it, don't use it. Tip number 2. Understand AI's limitations. AI tools do not understand law. They are not applying doctrine or evaluating precedent. They are predicting what words are statistically likely to follow the last. And that's it. Where it cannot predict, it invents something that sounds right. So as the Ayunde case explains, these tools can hallucinate plausible but false outputs. So plausible but false, it might be very fluent, it might sound very polished, but when it comes to law, fluency is not the same as truth. And we see the use of AI in drafting legal documents, using it to review contracts, etc., and even chatbots and intake tools. Imagine a world where an understaffed legal aid service is trying to help marginalized clients and employs AI to obtain some information via WhatsApp or via some sort of form on a website or chatbot on a website. Yesterday, I had a problem with my cable service and I wanted to request a technician to visit my home to repair something. The phone was too frustrating, so I went to the provider's website and interacted with an automated chatbot to log my request. This is becoming more and more popular, and it has already risen in legal spaces. But listen to this. In April 2024, an AI-powered chatbot created by New York City to help small business owners came under criticism for dispensing bizarre legal advice that misstated local policies and advised companies to violate the law. The chatbot, which remains operational to date, includes a disclaimer that it may occasionally produce incorrect, harmful, or biased information, and the caveat that it answers that the answers are not legal advice. If you need legal advice, contact an attorney. In responses to questions posed by journalists, the chatbot falsely suggested that it's legal for an employer to fire a worker who complains about sexual harassment or doesn't disclose a pregnancy or refuses to cut their dreadlocks. Asked if a restaurant could serve cheese nibbled on by a rodent, the chatbot responded, yes, you can still serve the cheese to customers if it has rat bites, before adding that it was important to assess the extent of the damage caused by the rats and to inform customers about the situation. So while some commentators observe that this highlights the dangers of governments embracing AI-powered systems without sufficient guardrails, the mayor of New York City, Eric Adams, suggested that allowing users to find these kinds of issues is just part of ironing out the kinks in the new technology. So the moral of the story, again, we need to understand the limitations of artificial intelligence. My third tip is to maintain human oversight. AI can be a great drafting assistant, but it's not a replacement for your professional judgment. Like a junior colleague, it might produce a decent working draft or first draft, but does it understand the client's objectives? Does it understand the rules of court? Does it understand evidentiary standards? We can imagine that if you had a human rights attorney who's working with a migrant client and doesn't speak the same language, AI might be helpful in terms of live translation so that you can communicate with your client. But what if you had to produce evidence to a court, a transcription of what the client said? Can you also rely on the AI to generate the transcription for the court? Does that meet a different standard? These are things to take into consideration. And I'm sure many of us are familiar already with transcription aspects of AI, where Zoom takes a note of what was said in the meeting. But I'm sure many of us know that Zoom's AI has a problem with Caribbean accents. So we can see that there is a problem using AI in this way, and that is why human oversight remains essential. The case of Matter versus Avianca Incorporated was the first reported case where hallucinated content was found in documents that were filed in any court, in that case in the United States. In that case, the court noted that AI, while a promising tool, is not a replacement for human responsibility and oversight. A lawyer is answerable for their research, arguments, and representations under the core duties to the court and to their client. My fourth tip is to protect confidentiality. Imagine that you are preparing for trial, so you upload the witness statements into ChatGPT and ask it to find inconsistencies among the witnesses, draft potential cross-examination questions, and summarize the statements so that you can create an opening argument. It's fast, it's efficient, it might even feel like magic. But now ask yourself, how private is that data? Where is that information going? Is it being processed on a server outside of Trinidad and Tobago or your jurisdiction? Is it being stored temporarily or otherwise? And more importantly, have you just exposed sensitive, privileged material to a third party without your client's consent? Public AI tools like ChatGPT, Gemini, or Claude typically route data through external servers. And unless you're using an enterprise-grade privacy-secured version like Lexis Plus, there are no ironclad guarantees about how that data will be handled. As the court in IND warned, you have an ethical and professional duty to protect client confidentiality, and that extends to the digital tools that you use. Just as we wouldn't shout out strategy in a coffee shop, we shouldn't outsource sensitive analysis to unverified tools. The use of private, so the takeaway from this is instead of using the tools like ChatGPT and Claude, the free tools, perhaps the use of private vetted platforms might be more responsible. It's best, therefore, to anonymize or even redact data before uploading to the free platforms, or even better, conduct that kind of analysis locally with software that you control. My fifth tip is to document your process. If you're using AI for anything related to your professional workflow, keep a record. What tool did you use? What did it generate? What did you do to confirm its accuracy? These checks and balances are not just about covering yourself. Documentation fosters trust. If your work is ever questioned by a colleague, opposing counsel, or the court, your audit trail can speak volumes. The court expects that practitioners will use AI, but the time has come to put systems and procedures in place at our offices on how we are to use AI. That brings me to my sixth tip. Train and supervise your team. So among the internal procedures that we should be implementing is training. The next frontier of risk is internal risk. Associates, paralegals, and interns using AI without guidance. In the next-gen case, the lawyer's assistant used Google and ChatGPT to source citations. The citations were fake. The lawyer didn't verify. The court then held him accountable. So leaders must implement clear expectations and build a culture where ethical AI use is the norm. That means training by rule and actively reviewing AI-assisted work. The phrase, "with great power comes great responsibility," was first spoken by Stan Lee, the narrator in the very first Spider-Man comic book, but there are two other quotes that we should embrace. Firstly, those with responsibilities must ensure compliance, and that's from the IND case. The second is, the integrity of the justice system relies on professional accountability, and that's from the Honorable Mr. Justice James in the next-gen case. My seventh tip is to be transparent about AI-generated output. Own your output. No matter how a document was produced, if your name is on it, it's yours. You own it. That includes paragraphs drafted by AI, sections summarized from email threads, or footnotes inserted by a client using an AI tool. IND reaffirms this. Professional responsibility is non-transferable, and increasingly, as NextGen also shows, the courts may ask whether AI was used in submissions. If AI made a material contribution to the structure or content of what you submit, consider disclosing that fact. This also raises the question about client consent to process their information using AI technology, and disclosure if AI was used to generate any correspondence, pleadings, advice, or even invoices. The next-gen pathology judgment explicitly states that if any material has been generated with the assistance of AI or other non-traditional sources, full disclosure to the court is both appropriate and expected. So a practical tip here is consider transparently disclosing the use of AI in your submissions if it has materially contributed to the content, especially for novel applications. My eighth tip is to check for bias and fairness. AI tools are trained on large data sets. Those datasets often reflect dominant perspectives, meaning outputs can carry implicit biases. They may reinforce stereotypes, overlook marginalized experiences, or reflect legal standards not applicable to Caribbean jurisdictions. Lawyers must therefore evaluate outputs for fairness and legality before adopting them. The rapid development of AI raises profound ethical concerns. These arise from the potential systems to have embedded biases, contribute to climate degradation, threaten human rights, and more. The United Nations Educational, Scientific, and Cultural Organization produced the first ever global standard on AI ethics, the Recommendations on the Ethics of Artificial Intelligence, in November 2021. This framework was adopted by all 193 member states. UNESCO's Assistant Director General noted that in no other field is the ethical compass more relevant than in artificial intelligence. These general purpose technologies are reshaping the way we work, interact, and live. The world is set to change at a pace not seen since the development of the printing press 6 centuries ago. AI technology brings major benefits in many areas, but without the ethical guardrails, it risks reproducing real-world biases and discrimination, fueling divisions and threatening fundamental human rights and freedoms. So when the AI generates its output, we need to double check. We need to apply that human oversight to make sure that that output is not going to be biased. My 9th tip is to stay ethically literate. The pace of change is rapid. Courts, regulators, and professional bodies are still developing their responses to AI. As Ayinde reminds us, there's no shortage of guidance, but that guidance doesn't matter if it's not read, digested, and applied. Ethical competence is not optional. Whether it's court bulletins, bar associations, or continuing legal education, we must stay current. When software engineers program AI tools, they must take certain ethical concerns into consideration. And the diagram on the screen shows a problem, and how would the AI resolve that problem? But for us, the core duties are an unchanging compass in a changing technological landscape. That is to act with honesty and integrity, to provide competent work to clients, and to maintain confidentiality. But there is now an additional duty to understand the implications of AI on legal practice by attending seminars like this, regularly viewing your professional body's guidance on technology and ethics, for example. The Caribbean Court of Justice has issued a practice direction in January 2025 on the use of generative AI in court proceedings. We must keep abreast of all these developments. My 10th tip is establishing an AI governance policy in your practice. We spoke earlier about systems and procedures. Responsible adoption isn't just about the habits of individual lawyers, but it is about creating a culture of accountability at the organizational level. Whether you run a solo practice, lead chambers, or manage a regional office, you need clear, documented policies on how AI is going to be used in the professional environment. Who is allowed to use it? What tools are approved for use? What types of work can be supported by AI? And what requires human judgment only? How are outputs to be reviewed and stored? The courts in both Ayinde and NextGen have made it clear they will inquire into whether leadership fulfill this duty to supervise and maintain standards. A proactive governance policy isn't just a compliance tool, it's a public commitment to ethical innovation and administration. So, what are my final thoughts? There's much scope for discussion and debate in these areas, but I think that we can end on this note. AI should not be abused by attorneys at law. AI is not a substitute for human thought and consideration. Regulation of AI is likely to become necessary in the legal landscape. And I think most importantly, the guiding principles of honesty and integrity remain central in any legal endeavor. Thank you.
Yep. So I want to thank you, Jason. Thank you for those 10 helpful points. Thank you to our attendees for staying on to attend what is now the question and answer forum. if you have noticed, Scott has been busy answering a lot of your questions already on the platform. So I want to thank him for his efficiency with that. So I want to remind everyone you can continue to use the Q&A platform, or if you wish, you can raise your hand and we will allow you to ask your question verbally if you prefer. While you continue to do that, I do have a couple of questions for our presenters. My first one is for Ian. Ian, you spoke a lot about the necessity for training among the bar, among firms, etc. In your experience, what is the extent of that training in the UK among the bar and among in-house counsel, for example?
Well, the answer's simple. At the moment, it's very, very limited, which is a polite way of saying almost non-existent. I mean, as you kindly said in your intro, am a professor at IE University, and I teach a course to law students, which includes artificial intelligence issues. As I travel around speaking at different conferences and different places around the world, I regularly ask other faculty people that I come across whether they're doing the same thing, and hardly anyone is at the moment. They're starting to. It's starting to happen because I think they're realizing the importance. But here's what's missing. It isn't just about saying this is AI. It's about saying this is how the legal profession, or how you as a lawyer should be integrating AI into what you do for the client and for the court. And I think we're going to start to get that, but at the moment it's very, very patchy.
Thanks, Ian. And probably just to throw the question out to Jason now, from your experience at the law school, how has the use of AI and the training, so to speak, for the use of AI been with students?
So we are in an era where students are using AI. Now that presents a challenge for legal education, and not just legal education, but education around the world, to determine the integrity of assignments, for example, that are submitted. Are they generated using the thought process of the students, or are they generated by AI? It's interesting that at the secondary level, CXC now has a policy on AI that they're going to be implementing for SBAs starting from 2026. And they're going to be incorporating the fact that secondary school students are going to be expected to use AI in producing some of their assignments for examination at a regional level, final examination at a regional level. So what's happening very slowly but surely, but we are getting students who are already versed in using the tools. In just using the tools. The difficulty now lies in that extra layer, as Ian and Scott have both said, the prompt engineering, knowing how to ask and refine the questions in order to get the desired outputs. And we must engage in that sort of training for our students. And I think that there will have to be curriculum reform across the university and law school level in order to embrace AI.
If I can just add, I want to just very briefly tell you a true story. I was teaching the last academic year, and I get everywhere I go early. I was the first one in the lecture theatre, but all the students then started to come in, and they all opened their laptops, first thing they did. And I realized that none of them were not only not writing anything, but they were not typing anything either. So I wondered what was going on. And in fact, what they'd done is they'd opened up their laptops, all of them, and they'd put on an auto-transcribe software. So everything I was saying was being automatically transcribed. And then they were using AI to run over the top of an auto-transcribed lecture which I'd just given. So I have to tell you, I went to the faculty and I said, look, this is what's happening. Well, what should I do? And the faculty said, we don't know. What do you think you should do? So, this was really cutting edge, and students are now behaving in a way that is going to require legal establishments to transform the way that they educate and assess people. Because now, if I say to someone, write me a 2,000 word essay, they'll do it in a fraction of a second. And it's very difficult for me to know how much of that was them and how much of that was the AI system. So what am I testing? What am I training for? These are things that we're going to have to grapple with, because we're going to have a series very soon of law students coming into law firms who that's the way that they've lived their lives. And we're going to have to try and find a way of incorporating that into an ethical and professional service.
Yeah, brilliant. Thank you, Ian. Thank you, Jason. We have one question in the chat. Should the legal profession consider requiring compulsory continuing education or certification in AI ethics and technology law, given its growing influence on due process and rights protection? I'll probably give that to both Jason and Ian again.
I'm happy to go first. I'm a big believer in continuing education for lawyers. I think it's part of the foundation that makes us a profession rather than just a job, is the fact that we are required to keep up to date and to maintain a certain level of ongoing education. And that therefore necessarily means that I think that AI and the other elements that you mentioned should be a part of that continuing education. I would go even further. I know this is not popular because nobody likes going back to school, but my view is that you should actually be required to do in all jurisdictions a minimum professional continuing education in order to keep your ability to keep practicing. That's my opinion.
So my short answer is also yes. And I really must applaud the work of the Continuing Legal Education Committee of the Law Association for having webinars like these on various aspects that affect the profession. And, the debate about whether there should be compulsory legal education is something that will require an amendment to the Legal Profession Act. I know that there is a committee actively dealing with that, but yes, I think that is the direction in which we should move so that we can stay current and stay abreast of all developments that could affect our practice.
Thanks, Ian. Thanks, Jason. Throwing this one out to Scott. If AI improves its reliability, would there still be a risk in using it?
Yes, I think there would. I think for all the reasons that we've talked about up until this point, I don't think that AI will ever be there to replace the work that legal practitioners do. I think it's there as an assistant, as an aid for them to do their job more effectively, and ultimately produce better outcomes for their clients and themselves. So yes, I think there will always be there will always be a risk and a need for human oversight. Absolutely.
Can I just add something to that as well, which is the proof, I believe, of what Scott says as being correct, is an analogy. The technology to replace what lawyers do, the technology to allow people to not use a lawyer has been around for 500 years, and it's called a book. And anything that I know or any other lawyer knows, in fact, way more so, you can walk into a public library in most cities and read it yourself. And you've been able to do that for many, many, many years, but people don't. And the reason they don't is because they like going to someone who spent their time, effort, resource in learning how to do this kind of thing. That will continue to happen. If I have a leaky pipe, I don't go to the library and learn how to do plumbing. I call a plumber, and this will continue to be the case going forward.
Yep, completely agree. Thank you, Ian. I do have one question as well for Scott. Could you tell us what are the new developments on legal AI?
Yes, I can, absolutely. You mean on Lexis plus AI specifically?
That's really from your knowledge, yes.
Yes, absolutely. So we are constantly updating and iterating the AI solution, as you can probably imagine. Whilst we were very much first to market, if we keep doing what we're doing, we'll very quickly be behind. We are about to launch our new AI assistant, which will rename the AI assistant Protégé, which will provide additional personalization. But at the same time, it's going to enable you to draft full transactional documents. It's going to enable you to upload huge swathes of documents to then analyze and use as source material for output. And we've also got what we call our DMS integration. So it'll allow you to integrate Lexis AI with your own content, should you wish to do so, which will enable you to source from the rich content sets, precedents that you yourselves have. And there are constant evolution of the service, as I said, to just make sure that we continue to stay ahead.
Yep, brilliant. Thanks, Scott. If there's any other questions from the attendees, now is your chance to do so. You can look at the Q&A section. You'll see Scott has answered some questions. Maybe a lot of you also have. And if you would like to ask a question verbally, please raise your hand to do so. In the interim, and until we get another question, because I want to make full use of the distinguished panel that we have before us, I just want to say thank you very much, Scott. Thank you very much, Ian. Thank you very much, Jason, for taking the time to participate in this webinar. In association with LexisNexis, of course. It has been a great crash course, I should say, in using AI ethically, getting the tips, getting the insight from all of you. I'm very glad to say that this webinar is recorded and will be on the Law Association's website for those persons who are financial members to be able to access. And I should also add, piggybacking of Ian and Jason's presentations, that there is a subcommittee of the Human Rights Committee that is focusing on artificial intelligence and those issues that clash there with respect to AI, the rule of law, and some of those issues that are up and coming. So the Law Association is doing its best to stay on top of these AI issues as best we can. So I'm seeing one last question. Stepping off of Mr. Nathu's answer to my first question, is there a case to be made for a regional AI Act, perhaps similar to the EU model, or is it perhaps more practical to integrate AI principles into existing sectoral laws?
I can answer that, Jonathan. I think it's interesting that we've had a change of administration in Trinidad and Tobago, and now we have a ministry dedicated to artificial intelligence, the Ministry of Public Administration and Artificial Intelligence. So it will be very interesting to see what developments takes place, whether any legislation will be piloted, whether there will be a regional approach rather than a national approach. And I'm sure in short order, we will be finding out the answer to these questions.
Could I just venture an opinion on that? Because I realize I'm probably in a minority of one here, but I just want to give a different perspective, which is that we must remember that we have had laws over a long period of time which cover the use of computers and computer programs and technology. And we have to remember that ultimately what we're talking about here is a computer program. It's a very sophisticated one, and it does a lot of new outputs, but ultimately it is a computer program. And so I would just like to leave you with two thoughts. One, that we already have a heap load of laws that cover the use of computer programs, and so we should be reluctant to create new ones when perhaps existing ones might cover the subject. And my second point is to remember that whenever people are reviewing this, that we always hear in the press about the scary side of AI. I want to balance that out and say AI gives us tremendous opportunities for advancement across all kinds of areas. So let's keep a balanced and open mind about both its contributions and its dangers.
Completely agree. Thank you, Ian. Thank you, Jason. For Jason, what circumstances do you envision would give rise to an obligation to disclose to the court your use of AI in preparing your case or your submissions?
Well, I suppose there are a number of potential scenarios that could arise. Of course, the court might just ask for it, as the court has said in NextGen. I was reading a discussion about a case in the US recently where AI was used to assist an expert in providing expert evidence to the courts. And then there was a whole debate as to what was the benefit of an expert who is trained in his or her field employing generative AI to assist in the outputs. I believe that the matter went to appeal in the US. So that is a I suppose an area where the court may want disclosure. Maybe if confidential information is being processed, for example. I mean, those are three things that come to mind.
Agreed. Thank you, Jason. And I think we've covered this one. Do you believe AI usage should be integrated into the Bachelor of Laws curriculum to prepare undergraduate students for law school and practice? Yeah, maybe.
Yes. Easy question. Yes. Unreservedly, yes.
Brilliant. So again, unless there's anything else from any of the attendees, I want to give my thanks once again. Scott, Ian, Jason, it has been a pleasure spending this time, hearing your thoughts, hearing your views, chatting with you and getting some guidance, I would say, for all of our practitioners online. So unless there's anything else from our attendees, no, I'm not seeing any more questions. Thank you very much to our participants. This has been a very well-attended webinar, I must say. Thank you for the questions. And please look out for more webinars from the LATT on this topic of artificial intelligence, but also for continuing education series. So without further ado, thank you, gentlemen. Thank you, participants.
Thank you all.